What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to talk more Kohberger information trickling out. The state has been very confident from the jump. They've got the right guy. They're going to win this case. The victims' families seem to be very confident that Kohberger is the guy. And as more information comes out in these motions, facts that they have known for a while that we as the public have not known, show the state's case may be stronger than people originally thought. It seemed like there was a lot of holes because we didn't have a lot of the information. And this was the case that I've said, we don't know everything. We don't know anywhere near everything. But today we learned some more facts. And we're going to talk about how the defense is going to combat them, how the state is going to use them. And you're going to listen and say, how bad is this for Brian Kohberger? Let's get into it. So we're going to read a couple pages of the state's response to the defendant's motion in limine number 9, excluding Amazon click activity evidence at trial. We're going to jump down to page 4, where it really gets into the meat of what we want to talk about today. Further, in this case, the evidence at issue is complete. The defense argues that the data the state has disclosed to the defendant is extremely narrow when compared to the more inclusive and broad warrants and subpoenas. But this argument is incorrect. To confirm, the state has disclosed to the defense all data, including clickstream data, that Amazon has produced in this case. The state narrowly tailored a search warrant for evidence regarding the crimes of homicide or burglary occurring at 1122 King Road. This included temporal limitations based on the officer's investigation, which limited the search from March 20th, 2022 through March 30th, 2022. At the time, doesn't say at the time it was known Brian Kohberger purchased a K-bar knife with sheath and sharpener from Amazon.com. So about 8 months before these crimes occurred, the state says they have proof that Brian Kohberger, based on his Amazon history or an account connected to Brian Kohberger, purchased the knife in question that it seems like is going to be the knife that is going to match what happened to the victims in this case. And of course, the sheath that was left at the crime scene. And November 1st through December 6th, 2022, time right before and after the homicides. Kohberger's entire click history, items not related to knives and accessories, was not relevant. Without any legal basis, the defendant claims the state cherry-picked specific clicks or purchases out of the Amazon click history. This is simply not true unless you consider seeking only items of evidentiary value cherry-picking. Irrelevant click activity on Kohberger's account would not provide any relevant context to Kohberger's actual click history, i.e. the purchase of a K-bar knife with sheath before the murders, and click activity indicating a search for a knife with sheath after the crimes. So a lot right there. Number 1, he purchased these items on Amazon. Number 2, after the crimes, he searched for them again. Why would you search for something again? The state's going to say, because they're gone. They're missing. Either you trashed the knife and you forgot that you left the sheath at the crime scene, so you're looking for it again because you want to buy more. Maybe you're going to commit more crimes. Now, the defense is obviously going to say it was stolen. That's why he was going to search for it again. And he had no idea what weapon would have been used at this crime because he wasn't there. He didn't do it. Now, is that a good argument? It's about the best you can do if you're the defense, but this does not look good. I wonder how many people ordered K-bar knives and sheaths in the 6, 8, 12 months prior to this crime occurring. How many of them drive white Elantras? How many of them have bushy eyebrows? How many of them match the description of the height and build that we think is going to come from the victims? How many have the opportunity to commit these crimes? How many of them are within the vicinity? How many of them are the state going to be able to argue case the joint? Now, I know the defense is going to be able to poke holes and have arguments against every single one of those. But as you start to stack things up that match one person, it becomes a lot more difficult for that reasonable doubt defense. It becomes a lot more difficult for that you can't prove it defense. If they can stack all these things up and it only really all connects on one guy. Yes, there are other people that have white Elantras of those years. Yes, they weren't perfect on what years they started with. And I think the defense will make those arguments. I think they'll be really good arguments. I think the defense is doing everything they can to fight for Brian Kohberger. But if you have ordering of the weapon used, allegedly, searches afterwards where you say the weapon was gone, the car, the physical description from, again, I think they're going to have a heyday with cross-examination on the physical description, the victim statements, what the victim saw, the intoxicated state the victims were in, the time that passed. There's all sorts of issues with each individual piece of evidence that has been alleged to point to Brian Kohberger in this case. But as we're hearing more and more, things come. Oh, I didn't even mention Brian Kohberger's DNA on the sheath, touch DNA, that maybe isn't the best science, and the defense is going to be able to attack that in all the different ways touch DNA can be transferred. But we are stacking so many things against Brian Kohberger, if we're the state attorney, that I can see where their confidence comes from. There are still issues. This is far from perfect, but this is a huge key piece of evidence, or multiple pieces. Not only the Amazon orders, but his clicks, the click activity. Kohberger's click activity is relevant and admissible. Under Idaho Rule of Evidence 401, evidence is relevant if it has the tendency to make a fact more or less probable than it would be without the evidence, and the fact of its consequence is determining the action. The defendant appears to argue that the evidence of the defendant's Amazon.com click history is not relevant. That's not the case. Yeah, I would agree that's not a strong argument by the defense. A K-bar knife sheath with a USMC logo was found next to one of the victims at 1122 King Road. The defendant's DNA was found on the K-bar knife sheath found at the scene. Applying the test for relevancy, first, Kohberger's click activity, which shows a purchase of a K-bar knife sheath before the homicides, make it more probable than it would be without the evidence that the K-bar sheath found at the crime scene was Brian Kohberger's. Second, Kohberger's click activity after the homicides make it more probable than it would be without the evidence that Kohberger had a reason to search for a K-bar knife sheath after the homicides. These facts are of consequence to determining whether Kohberger committed the homicides at 1122 King Road, the central question before the jury. This evidence is clearly relevant. I agree 100% with the state here. How can you not say this is relevant? Now, if the defense's argument is he was framed, it was planted, it was his knife that somebody took, and obviously because it was his knife in the past, it has his DNA on it. Somebody else took it, used it, planted it, framed him, fine. That all tracks with this evidence. So if that's their defense, it's going to be consistent with some of the evidence, at least. We'll give them that. Is it the strongest one? I don't know what else they have. Again, we're going to wait till trial to make any real decisions, but just trying to figure out how each lawyer is going to use each piece of evidence that trickles out. It's looking better for the state here than the defense with at least this piece of evidence. The defendant argues pursuant to IRE 403, the relevant evidence should be excluded. The defendant fails to show how this evidence is unfair, confusing, misleading, would cause delay, waste time, or would be cumulative. This is almost like the definition of relevant circumstantial evidence. That is because it is none of these things. What is clear from the defendant's filing is that the defendant doesn't like this piece of state's evidence. I don't blame him. The defendant's Amazon click activity, and therefore would like to keep this piece of evidence from the jury. However, his arguments are without merit. With this evidence, while this evidence is prejudicial, relevant evidence tends to be, it is not unfair. In conclusion, the state respectfully requests the court rule that the Amazon data received in response to search warrant, the click activity, is complete and this evidence is relevant and admissible. This is a footnote. The defendant touches on the issue of identifying the account user making the Amazon search inquiries as shown by the click activity. Defendant's motion on page 4, the state recognizes that the identity of the user making the inquiries is relevant, and the state intends to rely not only on the click activity, but also other circumstances to connect the defendant to the original knife purchase, and subsequent search requires for a replacement knife and or sheath. This will include the defendant's financial activities, the click activities vis-a-vis other events, such as the homicides, a related purchase activity connected to only the defendant, and testimony from witnesses with knowledge that the defendant purchased a K-bar knife. So that means they have credit cards for Brian Kohberger that probably correlate to, I made a spend on Amazon, used my credit card number, delivered to my address. There's all sorts of ways you can prove, even if he was logged into somebody else's account, right? You can have your credit card on there, your address, and other witnesses are going to testify that he ordered a knife sheath. All of that, again, very good evidence for the state. And this all comes from their response to the defense motion in limine, because the defense does not want this Amazon purchase or click activity to come in. You can understand why. It's very damning. I feel very confidently saying Judge Hippler is going to allow it in. I think it's incredibly relevant and damning evidence for Brian Kohberger. The defense will still have their defense. They'll still be able to poke holes, but I absolutely think this is something the jury should be able to consider when determining the just outcome and result of what happened that night to these 4 victims. So let me know what you think. Let me know how bad you think this is for Brian Kohberger. That's all we got. I think I'm catching something. So not sleeping a lot on spring break. We're having a lot of fun. So it's been great, but we'll see. I'll keep trying to bring you the videos that are interesting. So many people had questions and comments about this. Of course, we're still following Karen Reed. I'm going to be watching March Madness for most of the day, but I'll record something on the Karen Reed hearing at some point. Thank you guys for listening. Please hit that like button if you haven't already. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.